I'll introduce myself. My name is Brel Hutton Opaleke. I use they and them pronouns. I can rename myself here in the chat as well. I'm NASCO's Director of Development Services, and I am excited to be here presenting this alongside Liz Anderson, who's also here. Liz, would you like to introduce yourself?
Sure. I'm Liz Anderson. I use they, them pronouns, and I'm the Director of Education for NASCO.
Thanks, Liz. We've also got a bunch of people from a bunch of different co-ops here. I am currently, let you know, I'm calling you from Madison, Wisconsin, so I'm not calling from too far away, even though it's a Zoom thing. I'm a member of Yahar Cooperative Land Trust as well. And let maybe folks who are here do a quick round of names and pronouns, and then what co-op you're or co-op adjacent group you're representing here today or from today. And anyone can pop off mute and let us know who's here.
Hey, I can introduce myself. I am Noah. I go by he, they pronouns. I am the education officer for Madison Community Cooperative, and I am really happy that Brel and I could get NASCO here to do this fair housing training with us. So thank you all for coming.
Oh, I think I'll go. I'm Frida. I use she, her pronouns. I'm a current member of Nottingham Cooperative in Madison, Wisconsin, and formerly Taos. I was a member of Taos Cooperative in Austin, Texas. So continuing it.
I'm Anja Farron. I use she, her pronouns. I'm a part of Milwaukee Co-housing Community.
Hi, everybody. I'm Gabrielle. I use she, her pronouns. Nate is also here listening in. And we are both involved with Matcha, and we also both live at Perennial Co-op.
Hey, I'm Steve Vague, member of MCC, Madison Community Cooperative, and I live at Hypatia Cooperative. Use he, him pronouns, and yeah, I'm happy to be here. I'm glad that this is open to lots of organizations. Pass.
Hi, I'm Andy of Lothlorien Cooperative in Madison, Wisconsin. Also part of the Madison Community Cooperative, and currently membership coordinator for the house. So I should have done one of these a year ago, but now I'm doing it. All right. I'll use he, they pronouns. Yes.
All right. So just kind of kicking us off, Liz, do you want to bring us into this presentation?
Sure. So we kind of already did the introduction, so I will skip over that part and talk a little bit more about expectations for this. This is over Zoom, so take care of yourself. Come and go as you need during this presentation. I expect about an hour of training, and then we'll have some time for a guided discussion after that. And also the general disclaimer of we are not lawyers, and this does not classify as legal advice. If you have very specific questions about fair housing, please contact a lawyer. We are giving you the overview of the law and how it goes with co-ops specifically. So that is our intent today. And some agreements for this space and for most of our workshops are speak from your experience, and we also have the expectation that we can't always be articulate all of the time. Take your time to try and say things. If someone doesn't say something correctly or coherently the first time, give people space to get it right. Thirdly, move up. So if you are more of a quiet person, maybe move up into speaking. If you're more of a talker, maybe move up into your listening. Both are valuable skills that we should be practicing and leaning into our growing edges. And then lastly, consider others' intent when they are speaking or sharing from their personal experience. These are just some guidelines for our space today that we're trying to create. If folks have other ones that they'd like to suggest, feel free to drop those in the chat to help build our space together. Some goals that we have for our workshop today to go over is what is discrimination? who is protected from discrimination under fair housing laws? How are these laws enforced? What is disability, and what are some accommodations that co-ops and housing is allowed, required to make? Some policy recommendations for co-ops, and then we will get to discussions again at the end. So those are our goals for today's workshop. I will pass it over to Brel to talk a little bit more about how fair housing works.
Thank you, Liz. All right. So the Fair Housing Act writ large has a couple, is primarily focused on providing protections for protected classes in the United States. What is a protected class? A protected class is a trait or category and not a specific group. So this wouldn't be like a specific religion. This would be a trait of having a religion. These traits are protected from being used in making housing decisions. And unlike a lot of in anti-oppression theory, most protected classes, like these in the Fair Housing Act, don't really recognize power imbalances. So white or Christian are just as protected in fair housing as Black or Muslim would be protected in fair housing. So similarly, you're not able to give preference in either direction. There are there's like kind of a nested group of lists of what protected classes are. There are classes that are protected at the federal level under the Fair Housing Act itself. And these are universally applicable throughout the United States. So you cannot discriminate based on race, color, national origin, sex, family status, disability, or religion. And these are like the words that they use. There may be more appropriate words for any of these classes that have changed, but this is the current parlance of the text. So these are the protected class on the federal level. In Wisconsin, we have some additional protected classes beyond those of the federal. So in Wisconsin, we also have protections for ancestry, for age. So you can't discriminate against anyone as long as they're over 18 years old. You can not provide housing to a 12-year-old. Marital status. You can't discriminate based on order of protection or having a restraining order against someone. Sexual orientation, lawful source of income. And then recently there was a change made to Wisconsin fair housing. It is now illegal for municipalities or counties to put an ordinance that says that you can't discriminate based on arrest record. So now arrest record is technically is that's allowed in Wisconsin. It's important to note that while arrest record is now a thing that you are allowed to discriminate against or discriminate based on, there is a memo that that HUD put out, and HUD is the Department of Housing and Urban Development, it's the federal department, that states that if you do engage in discrimination based on arrest record, it is very likely that you will be engaging in a pattern or practice of discrimination because arrests are necessarily skewed based on race, especially. So Wisconsin now says that you're allowed to do this and that no city or county can prevent you from doing this. But at the same time, you may be going afoul of HUD's guidance on this. So you may still be engaging in discrimination if you follow the state change. So I want to just stress that even though that's there and that change has been made, it doesn't mean that it's a good idea to start going out and discriminating based on arrest record. Beyond that, there's also protections for those who are domestic abuse, sexual assault, and stalking victims. So you can't discriminate based on someone being of that status in the state of Wisconsin. Are there any questions about that? I know that was kind of a little that, especially that arrest record one's a little bit weird here. Hearing none, we'll go on to the local level. These are tied for Dane County, and the ones with asterisks are Madison specific. I think also for Milwaukee, you might want to double check what the local level ones are here, because those also I'm sure extend beyond those of the state. But in Dane County and Madison, we also protect against discrimination based on military discharge status, whether it was honorable or dishonorable, physical appearance, student status, domestic partnership status, whether you're a member of a tenants union, what your gender identity is, what your genetic identity is, what your citizenship status is, whether you are a recipient of Section 8 housing vouchers, your current or former homeless status, your lack of religion, but not just your specific religion, and you can't discriminate against someone for not providing a social security number on an application. Madison. Thank you, Steve, for including the City and County of Milwaukee protected classes. That's very helpful. And Fair Housing Wisconsin is a great source. For more information about any of these sources, definitely reach out to the Tenant Resource Center. For Madison or the Fair Housing Center of Greater Madison at fairhousingwisconsin.com. You can definitely get that information there as well, and they'll keep that up to date. So what constitutes a fair housing violation? So the Fair Housing Act, the federal act, lists specific behaviors or actions that are discriminatory. Violations are related to advertising or recruitment, and also to applications. That is if you are putting out an advertisement that is explicitly discriminatory, that says we're going to create a space that is exclusive to genderqueer 18 to 25-year-olds, that would be explicitly a discriminatory statement, right? But also your applications might also be considered discriminatory in ways based on what you put in your application. So you want to make sure that the application is also non-discriminatory. Fair housing also, so both federally and state, is going to expect you to require your policies and procedures that you use to choose members to be applied consistently. This is really important for cooperatives, especially if you have a cooperative with medium to high turnover. It can be really easy to want to constantly change your membershiping process, or hone this. That's important and an important part of membershiping. But whatever process you pick, you want to make sure that you actually apply it to every applicant who comes in. So they want to make sure that whatever process it is isn't going to be picked and chosen based on what could be the protected class of an applicant. Fair housing also considers the impact of policies and not just their intent. So if you look at that HUD memo that I mentioned earlier, they go in pretty great detail to explain that they really want to see whether or not there is a systemic difference in your successful applications based on on one of those protected classes. So if you have a policy that such as checking arrest records and making decisions based on arrest records that disproportionately impacts especially Black folks or something, you're likely to it's very likely that you're going to be running afoul of the impact test of fair housing. It's also really important to note that any action that is based on a protected class is a potential problem. So it is important to you can definitely do a lot of outreach to specific groups. But if you are making your decisions on whether or not you're going to provide housing to someone based on that protected class, that like can really start to be like an issue with fair housing. So that can't be like the basis for your decision. That said, fair housing does not prevent co-ops from making membership decisions. If a person doesn't meet the qualifications of membership, then you totally can say no. If a person shows up and is wildly disrespectful to your members, you can absolutely say no. You can. There are a lot of reasons that are not based in that are not based in someone's protected class. That would be a deciding factor on whether or not someone's going to be able to be able to go through the membershiping process in a co-op. So here's a list of a couple of like real obvious violations, right? So an obvious violation would be refusing to rent to someone because of a protected class, and like not telling them about why. That could be pretty obvious. Another obvious violation: falsely denying availability, just saying that it looks like we're all full up. Like that could be really obvious. Or offering housing with different terms to someone based on their race or ethnicity or other protected class. Less obvious violations that people might not pick up on might be requiring a larger deposit initially because of your perceived risk of a membershipper. Requiring some extra interviews, maybe because maybe people didn't really feel like they had like bad vibes or something, and that doesn't really come up. Offering only or some of the rooms that are available. If you're an apartment complex, maybe like showing only like one apartment that might show up. If you're a multi-room house, only showing an applicant one of the vacant rooms. This might be like a thing where it just seems easier for you to say like, actually, I just want to show them just one room and call it good, and say that there's 6 rooms available or something. But not allowing someone the choice functionally, it can fall afoul of steering. Discriminatory language in ads or discriminatory images in ads also can be a little bit less obvious. That gets into the like, maybe this is actually really obvious territory too. But it is really important when you're writing your ads that your ads don't hint that there's a preference given to people of a specific demographic. I mentioned steering a little bit. So steering is defined as discriminatory actions meant to steer housing choices based on protected classes. So that might be like if you, as a housing co-op or as an apartment complex or something, require families to choose certain rooms or certain apartments, or if you decide to put folks who have disabilities only in certain rooms, or only show some of the available rooms. The solution to this, to like make sure that like you're not on like intentionally or unintentionally steering someone to like a specific room, is to let the applicant choose and to show them all open rooms that they can, that they could reasonably to see. The rule of thumb here is applicants know what's best for their own needs. Let them choose. Another kind of definition here is limiting and discouraging. And this would be actions that are meant to prevent applications based on a protected class. So if you have an advertisement, again, like I mentioned, that shows a preference based on protected class, that would be running afoul of fair housing. If you have a quota of a protected class, that's also that would also be running afoul of the Fair Housing Act. Especially folks who are in there are a couple of exemptions that are there for some like student-only housing. You are like none of the co-ops who are here are that. So you don't have the like temporary lodging that someone's going to matriculate out of exemption. So that you're not going to be able to like set a like a gender quota or something. Statements of preference made on tours or in meetings. So it's important to note, like, it's not just your written things, it's also the things that you say. So if you say that there's like a preference to have like a, you know, like a gender balance or something, that is going afoul of fair housing. So it is really important to not like limit or discourage folks. And then there's like the really obvious things, which are like coercions and or threats. So like that would be really especially like tied to someone who's like, who is applying and then like exerts their fair housing rights, saying like, no, I actually want to see all of the rooms that are available. And then if you say like, well, it's a shame that you're not going to get in, you know, that would be, you know, coercion or a threat for someone who's applying. Similarly, on the back end, fair housing also applies to people after they've become a member. So if someone is a member of your co-op and starts and like notes that there is something that is that is a fair housing violation happening, which we'll go into a little bit later. If there if you engage in coercion or threats to anyone that is like helping a person complain or who is exerting their fair housing rights as a member, you're in the same boat. So you don't want to do that. So that kind of talks a little bit about like what is discrimination, or at least what sufficiently appears to be discrimination as to meet the definitions of it. The other end is what isn't discrimination. So any membership policy that isn't illegal is allowed is basically the box here. So as long as you're not discriminating based on one of these protected classes, and as long as your outcomes don't specifically create like a disparate impact, you're good. So if you're denying membership to an applicant who doesn't meet your member requirements, like that's fine. If you deny an applicant who can't pay rent or uphold the terms of the lease, that's fine. If you evict someone because they broke the contract, also fine. If someone is a clear threat to themselves or other members, that is grounds for eviction, or that can be grounds for eviction. So you can engage in that as well. And then if you enforce occupancy limits or like square footage rules that are already in existence in local law, like that's not discriminating. If there are actually like density maximums in a room, and if you say that you can't have 32 people in an 8x8, that's you're within your rights as the co-op to say like, okay, actually we're not going to do that. So I do want to note that like, especially that line on like a person who's a clear threat to themselves or others, there are a lot of individual like nuances in a situation like that. By and large, we strongly recommend like take a compassionate approach and we try to keep people in their homes when possible, but also like prioritize the actual and immediate safety of your other members too. That is important to recognize like what capabilities you have as a co-op, and to stay kind of like within your actual capabilities. Okay, I'm gonna hand this off to Liz to talk about how fair housing is enforced.
Thanks. So the first step of the process is someone makes a complaint. To reach out to the Fair Housing Center of Greater Madison is how you would do that. This is good information to have around. It should be accessible to members, and folks should have access. There's a lot of great resources as well at that website. I think I dropped it in the chat earlier, where maybe Steve did actually. So after a complaint has been made, then there is an investigation made. Generally, when they're investigating a fair housing violation, the Fair Housing Authority uses paired testers who apply kind of like secret shoppers to your co-op. So 2 different applications might come in around the same time. but differing on a protected class. The investigation is about putting the burden of proof on the co-op. So making sure that the co-op can prove that they are not discriminating. All of that is in your processes and based on what they find out based on their secret shoppers. Discrimination is rarely open. So the co-op needs to show legitimate cause for denying this person or discriminating, or not discriminating, I should say. Most investigations end in a settlement or a court order, but court orders are much more severe. So settlements think a couple $1,000s and court orders think tens of thousands of dollars. Settlements are generally faster and less legal cost. Court orders can be very expensive, as I mentioned. All right, so enforcing fair housing violations. So like I said, the punishments can be financial, but they can also be behavioral. Behavioral can mean your training, your co-op is required to go through trainings or to physically change their policies that caused damage, sometimes even public apologies. So behavioral are more actions, and the financial penalties can actually be punitive, generally paid by the co-op or individuals if it was an individual action, but generally paid by the co-op. Actual equal, I lost my deposit and lived in a hotel and the co-op owes me money. Actual fees would be in line with the costs that were incurred by the discrimination. Punitive would generally be more and in line with the pain and suffering caused from the co-op as compensation. An individual who's discriminated against is
the other way around.
Sorry. An individual who's discriminated is directly liable, not protected by the co-op. Sorry, bro. Did you have something?
Oh, yeah. So that is just saying that you don't have, you as a person who engages in discrimination against like an applicant or another tenant in the co-op are not protected by kind of like the liability shield of the corporation, because you are individually acting illegally if you are personally doing that, especially outside the co-op's policies. If you're working within the co-op's policies, then the co-op would generally assume that liability. But the important thing is that if you're not protected by the liability shield if you're engaging in fair housing violations. You can't just absolve yourself of the responsibility by saying that oh no, it was the co-op's policy to ask people what gender they were and then decide based on that. You don't have that protection if you engage in that behavior. So the co-op's policy might be wrong, you might be following that policy, but you still have to it is still your burden of responsibility to learn this and to not discriminate.
And it is still burden of proof on the co-op to prove that they're not discriminating, to prove that their policies are not discriminatory. So even if an individual is acting out, the co-op still has to prove that they are also not liable. So don't discriminate, and also don't let your co-op discriminate is the bottom line there. Okay, so who is exempt from the Fair Housing Act? So very small owner-occupied buildings with less than 4 units, that generally applies to single family homes who are not communally owned. Single family homes who are not using a broker or advertising also do not qualify. Lodging or temporary housing operated by private clubs. So this is generally thinking more like frats who can discriminate by gender and be gendered clubs. Cabins available for the weekend for members of private lodges, that kind of thing. Retirement communities, for example, can exclude families with children and have age limits and such. Certain single-sex housing like dorms, military barracks, monasteries. I'll have everyone note on this page, co-ops are not on this list. next slide. Co-ops are not exempt from the Fair Housing Act. It applies very well. Courts have found that co-ops are not private clubs in the context of fair housing. Co-ops are permanent and not temporary housing. Co-ops are open membership as a part of the cooperative principles and not private clubs. So it is actually right there in our principles that we are not private clubs. Even exempt housing cannot use discriminatory advertising or make statements to limit someone moving in. So even all those categories I listed before can still not use discriminatory advertising and make statements about limiting someone moving in. So there's a lot that it covers and only very little that it doesn't, is the important thing. I will pass it over to Brel to talk a little bit more about disabilities and fair housing.
Cool. I want to say welcome to the other folks who've joined us. As a reminder, the rest of this will be recorded for the rest of y'all. You can check that out afterwards. In our section here, we're going to talk about disabilities and fair housing. And first off, there are some definitions. So we ask, what is a disability in the context of fair housing? A disability is defined here as a physical or mental condition that limits one or more major life activities. Like that, especially walking, speaking, hearing, or seeing, working or learning, breathing, routine self-care. This ties to either a person having a history of such disability, or this also applies to a person being perceived as having a disability. And actually I'll go back here. Especially that perception of having a disability is important, because that ties to the idea of whether or not you are making a decision based on that class. You as the housing provider, if someone doesn't have a disability and you made an assumption about that, you're still making decisions based on that class. So that perception is included. So examples of disability, these could include hearing or visual impairment. This could include chronic addiction or alcoholism. It could include mobility impairment, chronic mental illness, any developmental disabilities, also HIV or AIDS is included under the categories of disability here. So there are protections and accommodations tied to folks with disabilities in housing. It's important to note that a co-op has an obligation to respect the legal protections of folks with disabilities, and an obligation to make accommodations for them. So a co-op can't prevent a person from making an accommodation at their own expense. An accommodation here is defined, right, as a change in the physical space or in the co-op policies that make it possible for a person with a disability to live in the co-op. So that's like what an accommodation is. Specifically, a reasonable accommodation here is a change that is both feasible for the co-op and proportional to the needs of the member. So like the co-op wouldn't be able to prevent a person who moves into the co-op to say that I want to spend $400 to install a grab rail in the bathtub, because I need a grab rail and I can't effectively enter or exit the bathtub. I need to bathe. The co-op wouldn't be able to say, no, you can't do that, or you can't have that done. The co-op could say, okay, you can have that installed, but you have to make sure that you have a professional install it, and you don't like just break the wall. The co-op could also ask that the person remove the grab rail when they leave, but most co-ops would just say like, okay, great, our tub is more accessible, hooray. On the other end, right, like a reasonable accommodation could also be that a member might move in and need a ramp in order to enter the front door, and they want you as the co-op to spend $400 to get a ramp and make it possible for them to enter the front door. It won't prevent anyone else from moving into the front door. It's a reasonable expense from the maintenance budget, and that's something you could totally do. If it's like, a one step up, it might not be a reasonable ask for them to say, okay, we'd like you to install an elevator system in order for me to be able to get up this step. If there's like something that like the co-op actually can reasonably do without like a significant change to the co-op's operation, or like a fundamental change to the co-op's operation, or an unreasonable expense, the co-op can definitely just do that as long as it is proportional to the needs of the member and is feasible for the co-op. This isn't just like physical spaces, right? Like it's not just about like ramps and guardrails. It's also important to note that your co-op is like an organization with programs that people have to do. And some of those things are going to be like differently accessible to different people. So like if people are required to do labor and someone is unable to do like every single one of the labor jobs because of a disability, it's very, very reasonable that that person asks you to either allow them to have preferential like dibs on a specific job because like it works for them and is something that they're able to do with their disability. Or it's possible for if there's a minimum labor requirement and they can't do any of the jobs, to ask that you all create a position that can still usefully contribute to the co-op, but that doesn't require the abilities that you might assume that some people have. So like the co-op should be like actively trying to get the person in, not saying like this is hard and we're gonna like pass on it. The co-op should try to see what's possible to make the space accessible to a person. Other really simple examples: reserve a parking space. I'd like to be able to park closer to the building. Something like that. Like you can make these kinds of things are reasonable accommodations. They don't change the fundamentals of what the co-op is, and they don't prevent someone else from engaging and using the co-op. So another thing that's a big topic here is service animals and emotional support animals. If you go to another fair housing training, and I do recommend that you do, to go to another fair housing training on like fair housing broadly. This is kind of focused in on the co-op example, but it's good to get the wider range here. Any of those trainings are going to spend like a good like 20 or 30 minutes on emotional support animals. We're going to have a discussion section on emotional support animals too, so like it's a thing. But service and emotional support animals are not classified as pets. So when somebody is moving in and they say that they have an emotional support animal, you're not asking if they don't have to go through whatever your pet policy is. So they are like federally, at least per HUD, like the only service animals that we're aware of are going to be like dogs and mini horses. They're the ones that are going to specifically do a specific task they're trained to do to support a person. An emotional support animal could be anything. It could be, it could be a crocodile. Like emotional support animals they run the gamut. That said, they like they're not necessarily like allowed to just like an emotional support animal doesn't then suddenly like get to just like run free in your co-op. This is supposed to be a reasonable accommodation. So anyone who has an emotional support animal like is still going to be liable for any damage to the building by an emotional support animal. They're not protected because against like an emotional support animal that bites if someone has like an angry parrot. Right, like these animals can't be expected to like pay a pet deposit, but on the other end they and they can't like be prevented from moving in just on the virtue of them existing, but they do come with like some liability for the emotional support animal owner. There are however, I'll note there are some exceptions here. So if you're a co-op member interviewing a person who's trying to move in with an emotional support animal or a service animal, you can ask for confirmation that that animal itself is a service animal. I'll say by and large, like, this is a really, really, really narrowly defined topic. And I strongly encourage folks to kind of just say, to like take people at their word if they say they've got an emotional support animal or a service animal, because especially in a co-op, and especially if you haven't gone through like this training or another Wisconsin fair housing training, it's really easy to run afoul of actual fair housing. So I recommend it kind of against going down this route of like confirmation, but I'll still note it. So you can ask for confirmation that the animal is a service animal, and that's the question. You can ask for confirmation that an individual has a disability if that disability is not readily apparent. You can't ask them what disability they have. You can't ask them what it's like to have that disability. You can't ask them any of that. And you can ask for confirmation that the animal that they are bringing is required to either treat a disability or to serve some sort of emotional support purpose. You can't ask how that animal treats that disability or emotional support purpose. You can't ask, what they do or how, like any of that. You can just ask kind of like those three things. Stay in that lane. And you can't like demand that they get a doctor's note specifically either. I should say that Wisconsin has more stringent wording about like what a landlord can ask than the federal. However, a state can't like more narrowly define the Fair Housing Act than the federal act. So even though Wisconsin has a more narrow definition of like who can say that this is or who can give confirmation, the federal act is just that would be a person who like could reasonably make a determination that this is the case. So it doesn't say that someone has to have specific qualifications to say that someone's emotional support animal is an ESA or that their service animal is a service animal. So by and large, go with what they actually say is an ESA. You can, as we mentioned, this is kind of a reasonable accommodation. If an emotional support animal or a service animal poses a direct threat to another member, there are definitely accommodations that can be made, and we'll go into that a little bit more later. But you can, if there's no possible way for you to balance the safety of other members with the needs of a person with an emotional support animal, you can state that we're unable to make this accommodation reasonably. If you do that, expect to get a fair housing complaint and plan for that. And that's not the end of the world. It might be that you'll get some reasonable guidance that tells you how you could do it. But also you can reach out to the Tenant Resource Center or Fair Housing Wisconsin to ask them too, are there any good ways for us to make this accommodation? Again, like the goal should be to get the person into the space as opposed to using this as an excuse to prevent someone from moving in. So that's that thing. It's always long. That's how it goes. So the other another section here is on mental health and addiction. Addiction or mental health status are protected as conditions. While those are protected, like the fact that someone is an alcoholic or is addicted to some other substance or has some other mental health issues, while that status is protected, misconduct related to those conditions is not protected. So if someone is using like illegal substances on the property, that action is not protected. The fact that they are addicted to those substances is. So it is important to note that like there is that difference. It's the actions aren't protected, but the status is. So you can you can treat those actions as separate from the condition, if they're, especially if they're endangering the health and safety of your other members. We'll note that like some of those accommodations that might be needed in order to make it safe and supportive for someone who has either mental health or addiction issues in your co-op might not be immediately obvious to you. That person is usually the expert on their abilities, and you can ask if they're like what if any accommodations might make it more possible for them to safely and reasonably engage in your community. That can be asked of a person in order to try and make it so that they're able to be here. Last kind of chunk here of reasonable accommodations that are just kind of some examples of these. Just kind of like wrapping this up here. You could put a parking spot near the door. You can get visual doorbells for people who are hard of hearing. You can get portable threshold ramps if you want to get make a threshold a little bit more accessible. You can have lower counters in kitchens installed, or lower peepholes and doors installed, and changes, as we mentioned, to labor positions can be pretty reasonably made. So that's that big chunk on disabilities, and as Liz mentioned in the chat, we will specifically go into what happens when there are conflicting necessary accommodations later on in the discussion section. I'll hand this off to Liz for common co-op issues.
Cool. So yeah, let's dive right in. Gender balance. Co-ops unfortunately do say this a lot. It's not a thing we are supposed to talk about and try and strive for. It's not a thing. There is no gender balance. Membership cannot be denied based on sex. So if that comes up a lot while you're membershiping, your co-op needs to get out of that practice. You can't mention it in your ads or advertising. The process cannot have a preference based on it. So generally don't have questions about it in your application process. If you're filtering based on that for interviews, that's also discrimination. Outreach to underrepresented groups is okay as long as it's without a stated preference. So if there's a women's group on campus or some other spaces that are LGBTQ or non-binary trans spaces and you're advertising in those spaces, that's fine. Just the ad itself cannot have a preference on it. So there are ways to promote getting your co-op in front of different people is totally fine, but just as long as your advertising is neutral and non-discriminatory. Yeah, federal law does not consider non-binary or non-conforming genders to be protected under this, but I think, I believe Madison does have that under a protected class. Brel, can you confirm that?
That was like gender identity. So yeah, that's protected.
Great, so that is protected locally. All right, cool. Next, children and families, another protected class. So membership cannot be denied based on family status. Similarly, there's a lot of things that could go wrong here about steering. So children cannot be limited to certain rooms or areas, and families should be shown all rooms, just like every other applicant. Saying that folks most likely won't be let in because they're a family is discriminatory. So discouraging folks is discriminatory. Bringing that up in the decision-making process as a reason to not let someone in is discriminatory. Parents are generally experts on their needs of their child and are the best judge whether the co-op is a good fit or not. The co-op can just offer themselves as they are, and based on that, the parent can make the decision. Co-ops should not be deciding for or trying to steer for the parents or the family. Yeah. Okay. Theme houses. So lots of co-ops have lots of different theme houses. Sometimes they're things like vegetarian or substance-free house. But then there's also like queer houses and POC houses that are specifically protected classes, interfaith house, for example. So there's the uncontroversial ones that are not protected classes and can just advertise vegetarian all you want. That's fine. The more protected theme houses should be kind of advertised as spaces that are welcoming to explore, discuss these identities. That is totally fine and totally legal in the eyes of fair housing. If that house is advertising that they use protected class in membershiping, that will probably cause more problems and probably trigger a fair housing complaint. And your co-op might want to contact an attorney about how to advertise or set up the description of that house in a non-discriminatory manner. There are lots of co-ops that have theme houses of protected classes. And again, it's just about how you express that theme and what practices you take in your membershiping. Yeah, we encourage you to reach out if you do have theme houses, and we have lots of examples that we can put you in touch with. Next is background checks. This is a little bit less common, but still a common question that co-ops ask. When do you use background checks? Should you use background checks? Generally, if you do background checks, you have to be putting a lot of work into background checks. So you have to have a legal and objective purpose for the checks. You must know what info you're checking for and how it will be stored. If you're just going crazy and getting everything, then where are you putting all that information? How are you storing that information? What information are you actually looking for when you're doing a background check? So you should be ready to know how you're going to use the information that you found. These shouldn't be considered, fishing expeditions. So if you're only sometimes running background checks and not always running background checks, that can often be seen as discriminatory. So there should be a checklist of when and why background checks would be triggered. And even then, that can be a very dicey process. So if you're running background checks, it should be very consistent and specific. And you should be able to explain and document the intent of the background checks and the results. Generally, I wouldn't recommend this as a process for most co-ops. It's very expensive, it's very lengthy, and it takes a lot of close bureaucratic work. I think there's there you go. Thank you for sharing that. Okay. Lastly, rejecting applications. This is another common co-op issue that can be fumbled. When you are rejecting, co-ops should require explicit reasons for members who block a membership application. So when you're having your discussion process and you get down to it and someone is blocking, there should be a reason that that person gives, and that reason should be documented in the minutes, in whatever decision document you guys keep. If that person gives a discriminatory reason for blocking, that is the moment in which the co-op's policies hopefully would kick into place and say, that is actually not a legitimate reason for blocking this person. This is also a protection for the co-op to kind of, everyone who has access to this training should watch this training to know what is an appropriate reason. Brel mentioned not meeting membership requirements as a major reason for not accepting a member. The burden of proof is on the co-op if accused of discrimination. So what you write down is, what you write down is protected class, it should be very obvious that you have violated fair housing laws. The co-op should have a written list and of all denied applicants, and keep this record and keep an objective record of all of these decisions. So going back and editing is not cool. Taking honest notes of the discussion and the blocks. This record can be confidential, so this doesn't actually need to be shared with anyone. This can be just under the membership person's purview. but this record is for if there are inquiries, if there are fair housing complaints. If someone asks why they are denied, you can choose to tell them, or you can have a blanket confidentiality on that. But building a culture with a clear expectation can help members express concerns safely and think through the membership process with an open mind and an understanding of fair housing.
And I would add to this section, it is very, very, very good practice to tell people why you denied them. It is the right thing to do to tell a person why you denied them. If you don't tell them, it should be very reasonable to expect someone to request that, and you should be able to provide a reason why they were denied. If you say you were denied because we voted not to give you a membership, that doesn't count. That's right. Like that's not a reason. If you say that you were denied because someone blocked you, that's not a reason. That doesn't count. So if you're doing like you can have an anonymous blocking system or something, but you can't have a reasonless blocking system. So you can say someone blocked you because you are because they felt because like in the past that you'd attacked them, you know, like that, or that was like that is a reason that you can say like we have reason to believe that you're a threat to the safety of one of our members, like that you can say, but you can't just say like we're blocking you and not giving you a reason. That opens you up really, if you do that, it opens you up really, really wide to not just fair housing complaints, but to also just innately being discriminatory. People make discriminatory decisions. That happens even after they've gone through a lot of these fair housing trainings. I've been in co-op meetings where someone is like, but can we discriminate based on this? And it's like, no. So it is really, really good practice to have a reason that the co-op agrees is why we're not letting this person in, and to tell them that. That will, it's both good cover your butt kind of practice, and it also like lets the person know when they're applying really like that they weren't unfairly discriminated against, so that they're not wondering that, and then you know, kind of spinning their wheels and using up both their own resources, the resources of the fair housing authorities in Wisconsin and Madison, asking that. Like it is best practice to let them know why. If you don't have a policy that tells people why, like I cannot strongly enough encourage you to engage in implementing that as a cooperative, because otherwise, if you have it set up so that someone can just block a member and not explain why, you as a co-op may never know whether or not that person was doing so discriminatorily, and you as the co-op are still responsible for that person's actions, whether or not they, you know, whether or not like, you know, you all voted or anything, if like a single person can like block a member. So it is important to really, really kind of hammer that home, that folks should be given clear reasons that are not discriminatory, and that are real. So it shouldn't be made up after the meeting. And it's entirely reasonable as a co-op if someone decides that I'm going to block a membershipper and they don't say why, and they say like, I don't know, co-op, come up with a reason, you can ignore that block. That block is an illegal block, or if they're not gonna tell you why, or like, you know, like you have every right to, as the co-op, say like you're not willing to take that risk of potentially discriminating against someone because of some unknown reason. You don't have that, and so that defaults to it being a discriminatory reason, or at least you should assume that it defaults to that if you don't have that information. So it is again best practice. Let people know why, and record why. that will also help you look back at your past decision making process, at like, what did we like not let people in because they weren't able to meet the terms of membership, or did we not let people in because we just had too many darn membershipers and we stopped reading applications or something. Like you should know why you engaged in this. Yeah. The next thing we got here is policy recommendations. After that pretty hard policy recommendation. So tied to advertising, if you have any kind of policies on advertising, you absolutely want to avoid discriminatory language or images. If you have a policy on how you do advertising, it's really good to focus that on your mission and programs that your co-op actually does. You can definitely like use images of your rooms and commons, and to talk about like the facilities and services that are provided. But it's really best to avoid the demographics and current culture of the co-op as like something that's baked into your like your outward facing advertising. It's kind of interesting. Craigslist does a really good job of kind of saying, advertise features, not personal characteristics, when they're talking about the things that like, or when they're talking about their ads, right? Like you want to say like what's there, and what are people going to be expected to do, not who are we looking for. And that's really it. Because your demographics and culture are going to change over time. If they don't, your co-op is probably not really engaging too much in your demographics and culture. But if you're advertising culture, you might not really be accurately telling people what they might be getting into, because that might change. Even in co-ops where you have a person, or where you have folks, stay for the rest of their lives, 20 and 30 years, a single person's entrance does change the culture of the co-op. So it's important to more focus on like what's here, and what's not going to change. Explaining the process. So if you have a membershiping process, which I hope folks do, it's important to detail the application steps as early and clearly as possible. If you got a website, maybe having an FAQ. If you have, if you can't show all the rooms, like for some reason or another, do try to get a photo, or at least provide really detailed descriptions. Same thing for apartments. If you have an apartment style cooperative or co-housing community, you want to do the same for every available unit. It's a good idea to recap the membership process during tours. So if you say like you have a 3-meeting process and people have to show up to all 3 of them, to remind them, oh, hey, thank you for coming to your second. We'll see you at the next one. And then after we see you at your final meeting, we're going to, as a cooperative, take a vote and look based on your interview questions that you've had here, your application, and your statement that you're able to cover the costs of the co-op. We're going to make a determination as to whether or not we're going to give you a room. Like that's like letting people know is important. During meetings, when you are meeting as the co-op, it's important to remind the members of the co-op how that decision is going to be made each time that you make one. It's a good idea to clearly state the criteria for membership before making decisions. So if you're having a membership meeting, remind everyone what what qualifies someone to be a member, and then have your decision. There might be other things, maybe someone was if you're doing like pool membershiping or something, you might be deciding amongst 20 people or something, and you can weed people out if they don't meet the qualifications, or they seem that they're not going to meet the qualifications based on non-protected reasons. If someone says that they have kind of sketchy income, maybe you're going to go with someone who has more stable income, or maybe someone says they have really sketchy income and you actually want to provide housing to people who are more financially unstable. You know, like that's fine. But like you want to you like your situation like may vary, but like you want to know what the minimum requirements are up front. And then what's also important is as a person who's gone through a training like this, remind the other members who are making this decision with you what's out of bounds before they actually make decisions. So it's a good idea to just be like, all right, look, we're not going to discriminate based on this list of things. Questions about this list of things are off limits. Comments about this list of things, we're not including them. If you start going down that rabbit hole, we're going to shut it down. You know, like just like upfront, it's like that would be like good facilitation during a membershiping decision, to let people know what's going to happen. And then, you know, you can also have folks show up and watch this recording later on too. That's very helpful too. So you want to use clear criteria for your membershiping decisions. So this will be different for each co-op. You all have different needs and goals, admissions. So when you're deciding on a member, you want to avoid subjective reasons. So if someone says that someone was creepy or like wouldn't fit into the house or like probably wouldn't be happy here, if you anything like that, that's really subjective. That could be very easily based on a protected class, and someone's just not saying it. So that is like not something that you would want to say is like a valid reason for denying someone. Instead, you would ideally want to use objective reasons, or at least as close to objective reasons as is possible. So a person showed up and like used disrespectful words, or inappropriately stared at someone for, you know, like an extended period of time after they told them to stop, you know, or wouldn't commit to our policies on appropriate conduct, you know, like those kinds of things are a lot more objective, and are the kinds of things that you can say like, okay, this actually happened, and this is why we're really going to deny this person, and we know that that's not something that is like tied to a protected class. So related to that, you also want to record every membership decision somehow. So like that can be in your meeting minutes. That could be in a like separate membershiping like decision record place that you have. In either case, you want to have a date. You want to have how that decision was made. So if you have like vote count, or if like you make decisions by consensus, to say that we had consensus, and then reasons for rejection for anybody who is rejected. So that's like important to include. If you want to include like reasons for acceptance for people who are accepted, that's also just fine. You can say that on kind of on the flip side, like if you rejected everybody else for every other reason, like you can say that this person was better than the other applicants for that list of reasons. But especially for people who were rejected, have at least one good reason why that person was rejected. So tied to this, creating clear criteria, objections to an application can be really personal and can be really sensitive. So that said, most personal objections can be said non-discriminatorily. So you can discuss the positive traits of a good member when there is no application pending. And you can support, you can also like support members in finding language to express their concerns. So if someone says like, I didn't feel comfortable around someone, you can say like, okay, that's real. That might be like a reality, but like you want to understand like why you didn't feel comfortable around this person, and like what it was that this person was like saying or doing that that made you feel uncomfortable around them, as opposed to I just felt uncomfortable and then like we're going to call that the reason. So definitely support people who are doing that. And you also want to clearly identify in advance. If your co-op uses background checks, I think we note background checks a little bit later too. But if your co-op uses them, you want to clearly identify any of the like disqualifying issues that you are going to be looking for in a background check in advance of doing the background checks. So you shouldn't like just look through the background checks and say like, okay, we're like looking for just people's background and then we'll make decisions based on the background. Instead, you need to have like this is especially important with background checks. You need to have a policy that says what things that we find in a background check are going to disqualify you from membership, and we're going to, and you need to stick with that. This also ties really closely to that HUD memo about things that create a disparate pattern of practice, especially people of color show up disproportionately more having negative like things show up on their background checks. So just because of higher rates of engagement with law enforcement. So if you're doing background checks, you want to you can't just say like you don't want to say anyone having anything like any kind of criminal background is a disqualifier, because that will almost necessarily create a discriminatory practice. Instead, you would want to say like, okay, our co-op requires members to handle the co-op's finances. If a person's been convicted of grand larceny, maybe we're going to say that like, or like some other, like financial crime or something, we are going to say that that member we would not accept in like that's an option that you could say, right? Like you could also make a reasonable accommodation to say like a person who's been convicted of a financial crime, is it possible it's allowed for them to be a member, but we have to let them know that we're not going to make them our treasurer, like that that's up to you to kind of decide what you're going to do, but it's important for you to decide in advance and to set your criteria to be applied the same all the time to everybody. So you can run background checks, just stay the same. Notification of the applicant. So consider a standard letter for folks when they're rejected. It's a really good idea to be clear about the timeline too. People should know when they're going to get a rejection letter, if they are going to get one, and if you're late, let people know that you're late. Process can be punishment sometimes, so people should know when they expect a response, and if they don't get a response back, or they get a response super late, that, especially if you always respond late to all of the queer folks, maybe there's a pattern or practice of discouragement happening. That if you've got a standard letter that you send out, that can be really, really helpful to make it easier for you to send the letter that says people don't get to move in. It should be short and factual, ideally. You should say that we can't offer a room at this time for this whatever reason. You should make it clear that the co-op does not discriminate based on protected classes. You can give more details if you're asked, if the member or the applicant requests that. It's often a good idea to include the criteria that are used in membership decisions if you so desire, and you can give the specific reasons for rejection if needed as well. So you can be pretty boilerplate. You could say our co-op doesn't base membership decisions on the basis of race, religion, et cetera, or any other protected class. We've decided to deny your application as you expressed that you wouldn't be able to come to all of our cooperative house meetings. thanks for applying. You know, like that's pretty simple, and that's okay, right? You don't have to go any more detail than that. You could create a co-op appeals process if you so desire. You can certainly make it possible for a co-op to appeal to the co-op if they feel that that y'all made an incorrect or like unfair decision. That appeal should be based on the facts of why they were rejected, though. So if you denied someone because they said they wouldn't show up to the House meetings, and they appeal and they say, well, you deny. They say that like this wasn't fair because I have a kid, and I you know, like that it might be tied to that, but it would have to be tied to like the fact that like they weren't going to show up to House meetings. So it's like okay, great. Were you can ask them if they were not going to show up to House meetings because, you know, like they were at a time that they would have otherwise had to watch their kid. Could we make a reasonable accommodation to move them in order to meet their needs? You know, it should still though focus on like the facts of why they were rejected, and not like a completely separate point. Not like they were the greatest co-opper ever and you just didn't see through. If they feel like they can address this fairly within the co-op, less to complain there, then there's less to complain from outside the co-op. It's important to remember that like you might have been wrong. Like it's okay. Like you might have made an incorrect decision as the co-op to reject someone, and that's okay. And having an appeals process allows you to kind of like go back and make good on that. We've got a couple of discussion scenarios here. So this is a little bit less of us talking all the time, and I'll hand this off to Liz to intro these.
Yeah, so hopefully y'all feel comfortable unmuting and chiming in for this next thing. We've got several different scenarios, and this is a fictional co-op, so we respond how you would in your own co-op. Pretend for now that we're all in one co-op. These are anonymized events at co-ops. Oh, bro, would you go to the next slide? Great. Think about how these might play out at your co-op, and remember the community agreements that we had from earlier. Speak from your own experience. It's okay if we can't all be articulate all of the time. Be generous with each other, and consider your impact. And not every question that we're going to ask has a clear answer right now, but just use your skills from this training, and let's go for the first scenario, bro. Cool. Can I get a volunteer to read our first scenario?
Yeah, I can read it for you.
Thank you.
Okay, social pressures. Members at the Raised Bed Co-op were discussing the membership application from Jason, who disclosed their history of substance addiction and their treatment regimen. Jason shared that they've been sober for several years and have maintained their treatment, but wanted to make the co-op aware of this part of their life since it would come up anyway. A current member knew Jason and confirmed their sobriety. In the meeting, Sarah, the board president, brought up concerns about Jason. Sarah didn't know Jason, but said they were uncomfortable relying on Jason's sobriety at the expense of the safety of the house. Sarah went on to speculate about what could go wrong if Jason moved in and threatened to block the application. Their comments were seen as alarming or offensive by some members at the meeting.
Awesome. Thank you for reading that. So here are some questions to kind of help kick us off talking about this scenario if it were happening in your co-op. Does Sarah have an obligation to explain their thinking instead of just listing a reason to help members decide whether Sarah's concerns are discriminatory? So does she have an obligation to continue to explain this? can also use the chat. Yes, no, thumbs
I
up.
mean, I would say yes, because she is making a decision based on this person's protected class, and the facts that were given in the membership meeting don't seem to support her concerns. So I think it's fair to ask them to identify that further. Sorry, I used the wrong pronouns.
And you're correct. And I think also it's also fair to call her out on those concerns, because she's definitely already kind of saying some things that are falling into protected classes, definitely. Are other folks liable for the outcomes of Sarah's comments if you don't say anything? Is the co-op liable if folks don't say anything and just proceed to let these decisions go forward?
Yeah, I would say yes. It's the responsibility of the co-op and the other members that they're not making any membership decisions based on protected classes. So if this is Sarah's concern, it shouldn't be accepted as a block or as a decision.
Right on. The co-op is not liable for her comments, but the co-op is liable for the ultimate decision that is made. So Sarah is liable for her own comments, but the co-op is liable for the decision. Awesome. The last question is, you are sympathetic to Sarah's concerns about safety and feel a little defensive when people imply that these concerns are discriminatory. How do you handle that feeling?
I guess I can answer. I guess with this, since it is about a protected class and it's, about mental health, I guess the approach is that you would trust the person to know their needs best. And if they express a need or an issue that they have, and, they share as much as they want to share, and share that they're sober, for instance, like, it would seem cynical to assume that they're lying, and don't know themselves best. So, the membershipper knows himself best, not the people around. So
I think that's a great way to handle those feelings when they could come up in the room and be brought up by members. I think also saying concerns for safety is reasonable, but the reason for those concerns could be discriminatory. So basing that on mental health or addiction would be discriminatory. If this person exhibited unsafe behavior, that would be a very different thing. But based on objective versus subjective, reality versus speculation is also a good way to kind of put it.
Can I just ask a question? Just kind of going off of this topic, but a little different. Like, would it ever be considered a reasonable accommodation? Or I guess, are you expected to ever do reasonable accommodations for like mental health or addiction, or are those considered disabilities?
So like, yes, yes to both of those things. For mental health or addiction, like in fair housing context, those are considered disabilities because they impact one's ability to engage in their life functions. And yes, it would be normal for the co-op to attempt to provide a reasonable accommodation for folks who are who have either addiction or mental health struggles. What those accommodations might be are always going to vary based on the needs of the individual. So
Is there any kind of standard on what would be considered a reasonable accommodation or not?
Yeah, there are. By and large, a reasonable accommodation is one that would not make a fundamental change to the use of a space or the operations of an organization, and that would be like an absolute fundamental change. So like the co-op can't operate as a housing co-op, or like the members can't use the shared kitchen at all, or something, right? Like this would be a fundamental change. The other part is an unreasonable expense, and that is fuzzy, where that line hits, but it's usually pretty obvious whether or not like such an accommodation is something that the organization can bear. Like, can it continue to provide the services that it needs to the other members of the co-op? Can it do so without like putting itself in financial jeopardy? Can it do so while not having to pay unreasonable amounts for like rush work or something? So it is like the cost one is probably the most wishy-washy, where like the edges are, but that's the definition that is usually used. And I see Steve with a hand.
Thanks. I just want to give like an example of, I think Noah was asking about reasonable accommodations for people with substance abuse issues or addictions. And I'm curious about that too. I know we had an issue like that at my co-op at one point, and we just got together and decided not to keep alcohol in public spaces, not to store it in public spaces, right? So store it in your room, drink it wherever, but not leaving something so that a person who struggles is going to just wander through the pantry and see a bottle of vodka sitting on a shelf unattended all the time every day, right? And that was helpful, right? But do you know of any other guidelines or anything about, or suggestions about accommodations for people specifically with substance abuse issues? Pat.
Those are the primary requests that I've seen for folks with substance abuse issues, has mostly been folks with alcoholism and not wanting to keep that readily available. Some co-ops do operate as substance-free zones in general. So some of those co-ops like are inherently a little bit more accessible to folks who have substance abuse issues, and so like they operate entirely on that in that way. But that's what you mentioned is like the most common version of what I've seen.
If a house were to decide not to keep alcohol in private spaces upon request, would that be considered discriminatory behavior?
So that could start to kind of get into the lines of where that might be. Like it's not hard for the co-op, unless it was really hard for the co-op to not do that. That is a pretty low-hanging fruit to allow someone with a medical condition to live in your space. So you as the co-op would be kind of pretty actively saying that we're not going to do this pretty low-hanging like free action to make it more to make it possible for you as a person with a medical condition to live in this space. So that I would say is would be pretty close to discriminating against a person with a substance abuse issue, to not do that. And certainly would be a reasonable basis for someone to bring up a complaint if they were to bring one.
Yeah, I ask because we also had a similar situation in a house that I have lived in. There was more to the request than just keeping alcohol in private places. There was also the request that it be consumed in personal rooms, which people also objected to on the grounds of their own mental health needs. So that's why I wanted clarification, because there were concerns on both ends about mental health and addiction needs.
Yeah, and in that case, then we'll actually we'll have another scenario a little bit tied to that with kind of conflicting reasonable accommodations. In some respects, there is also like the ability for people to use to have like quiet and peaceful enjoyment of the premises, and that shouldn't usually be abridged by an accommodation. So it is that is hard to balance sometimes, and the specifics of that like individual case are also kind of like tied to, right, like you're balancing different people's mental health needs, and in a case like that, if you are unable to figure out a reasonable accommodation, you can sometimes reach out to you could actively reach out to fair housing to see, like, is there a way that we can figure this out in order to make it possible for a person to come in. You can also say, like, if you really can't come up with a scenario in which this works, you can say that we can't come up with a scenario in which this works after we've tried, and you can document your attempts to make this reasonable accommodation. You should document your attempts to make the reasonable accommodation. And really at that point, then you might say, okay, like, we can't do it. But it should be a really serious best faith effort to make it possible for a person to inhabit the space.
Gotcha, thank you.
Right. We've got another set of questions that are here about kind of the social pressures on that. Do you think that the members might have been able to, like, lower the emotional temperature down from Sarah's comments on that without disrespecting Sarah's concern for safety? And how might they have done that?
I think you can ask for clarification of what specifically about the person made them concerned. Kind of going off of what Liz said earlier, if they said that they were sober and stable, but they acted in a way that was maybe contradictory, or if someone close to them maybe had information about that. I don't know if I don't know, maybe, perhaps, but if they acted in a way that was contradictory, maybe that would be a reasonable concern, as a way to cite their concern in a way that isn't just feeling uncomfortable.
Great. How about like speaking up to voice a concern about whether denying Jason's membership application would get the co-op in trouble? If you're concerned about that, how would you bring that up to the group?
Sorry, could you repeat the question?
Yeah. How would you speak up to voice a concern about whether denying Jason's membership application would get the co-op in trouble? If you're concerned about that, how do you bring that up in a meeting like this? For what it's worth, it's also okay to just say that you're concerned about that. Yeah, let's just outright here. We note that just so that we can get to the next scenario here, we note that like this is like in this case, Sarah retains a position of authority within the co-op. This, regardless, is a responsibility of all members who are involved in membershiping to, if there's a concern, if you have any kind of concern that your co-op might be acting discriminatorily, it is your responsibility to bring it up. So you can say that you're concerned about it in that meeting. I see a hand.
Yeah, I have so with the hierarchy thing, if you have a membership coordinator in your co-op, do they have extra responsibility?
Yes and no. So in a membershiping meeting, if everyone's like, it depends on your co-op's like bylaws and organizational documents. But if you have a meeting where everybody is deciding on accepting a member, everyone who's there and who gets to decide carries equal responsibility in that decision-making process. That said, if you have a membership coordinator or a person who's doing all the outreach and communication with applicants, they do have extra responsibility in that action. So they do have the responsibility to make sure that they're getting back to people who apply. So everybody who applies, they should be responding to. Whether you're accepting applications or not, they can set up an autoresponder to say that we're all full, if you're full, but everybody should be getting responses. They shouldn't be cherry picking the responses or like the applicants. I have definitely heard of this happening in cooperatives where the membership coordinator only forwards some of the emails to the house. That is absolutely unacceptable. Unless those applicants clearly do not meet the qualifications for membership, and that membership coordinator is telling them that, and they've been delegated that responsibility. Right, yes, they carry extra responsibility, but it's not more responsibility than every other member who's part of that system to execute their duties in accordance with fair housing. It's a good question. I see a question from Jason.
Yeah, hi. Jason with Loth, he, him. I'm a little nervous. This is my first time doing any kind of Zoom meeting or anything like that. So I just wanted to discuss real briefly, just getting back real quick before we move on, with respect to the reasonable accommodation for people with mental illness. And I personally have been dealing with disability in terms of mental illness for 16 long years. And I have good mental health days and I have bad mental health days. And one of the things I was thinking about, because people were kind of asking about reasonable accommodations for people with mental illness, like what could they be? One of the things that I was thinking about for myself personally is a lot of times I really feel like I need to withdraw and kind of negotiate my these what I would call bad mental health days on my own and try and focus on self-care. And one of the things in terms of a reasonable accommodation is if these can be like weeks sometimes, these bad mental health things. So what I'm getting at here is one of the reasonable accommodations could be like, if I'm having like a bad mental health day, but there is like a house meeting, for example, one of the reasonable accommodations could be like not making attendance to that house meeting mandatory or a deal breaker on my contract. And I'll just pass with that. You can comment.
Yeah, thank you, Jason. Yeah, especially recognizing what things are essential for the co-op to operate. and for you to actually engage in the co-op, or like that's a big that's a big consideration. I've also seen co-ops allow for either remote participation or like absentee voting if there's like a required vote or something. If you do something like that, where like if someone's like going through it at a time, it's not super helpful to say like, oh, someone can vote absentee if we like made a spreadsheet during the meeting for people to do that. Like, try and get your your notes and stuff out early so that people can actually do that. And like maybe like have a moment where they can like sit and engage. So like there are little things that you can do to like make your meetings and like other member interactions a lot more accessible. And thank you, Jason, for sharing that to kind of like broaden the scope of ways that we can provide reasonable accommodations.
You're welcome.
We're gonna skip ahead to our last scenario here for time, because this is what shows up the most frequently. Will somebody be able to read this section on conflicting needs? Got Steve?
Conflicting needs. The Veer Left Cooperative received a membership application from a potential member, Catalina, who needs a service dog for their daily life. Catalina seems well qualified, has experience with co-ops, and is enthusiastic about membership. The co-op only has one room open at their Mondragon Manor house. During the review of applications, one of the members at Mondragon Manor, Aaron, raised a concern. Aaron has a severe dog allergy and would have serious health problems if a dog moved into the co-op. Pass.
Thank you, Steve. So here, on conflicting needs, is it legal to reject Catalina's membership application because of Aaron's allergies?
Can I ask a question, please?
Please.
Sorry, I couldn't find the hand raised. I apologize. So this, I think, is actually something that's come up within our house in the past specifically, and this is something that I've wanted to ask about recently. So if a member has an ESA animal, what is like the way I see this in my mind is you have an ESA animal, you live in a private apartment. It's in your apartment. You know, no one, in my mind, with interpretation of such things, would have reasonable allowance to complain because it's in your private dwelling. If it goes in the hallway, then I presume the landlord could be like, hey, your animal's in the hallway. This person across from you has an allergy. It can't be in the hallway. How does that work with co-ops? Is the living room considered the same thing as the hallway in an apartment building? Like if someone has an allergy, can they say, hey, this can't be here because it's going to make me sneeze and have a reaction, so on and so forth? Is it completely different? Please elaborate.
Yeah, there are a lot of like architectural differences between co-ops. I'll note. Like in a co-op, it's not a strict like this applies everywhere, because a co-op could also be separate apartments. This question seems you're at Lothlorien. This is a response tied to single room occupancy bedrooms in a shared living building, which is that an ESA in those spaces can be limited from using certain common spaces within reason. So it is reasonable to say that an ESA like wouldn't be able to be in all of the common spaces of the building. Like you could put limitations on that. In Lothlorien, especially, you have multiple floors that all have doors that separate them. You could designate a floor that is locked off, and say that there's the possibility of like if a person is willing to be in a different room, then you'd be able to meet both those reasonable accommodations. but that's only if they're willing to do so. You can't, as I mentioned, like you can't like steer people to like to a specific unit based on their protected class. But you can say that if you are here, this like this actual outcome is different, in that you can say that you're not actually going to be you're not going to be endangering another person health by being in this space. How does that, does that work for you? You can be in, you could be in any of the other rooms. In a space like that also, with an ESA, usually you would want to talk to the people who are going to be impacted by that and determine like the degree of impact, what they actually need. Does that person need that animal to never ever leave the room in order for them to like not have crippling allergies in the space, or does that person need the person with the ESA to keep the halls and spaces clean, or like keep their dog or cat or something groomed and monitored in common spaces? So there's a lot of there are a lot of gradients of like kind of where you're at and what the actual needs are. It's no one needs that a person to not have an ESA. That's not what the other person needs. What they need is to not be they need to not be living in a situation in which their health is compromised. So having the ESA in the space has to not compromise that health, and there are ways that you could potentially do that. And so you'd want to take steps to make sure that the emotional support animal is not compromising that other person's health. What those steps are will vary based on your architecture.
Interesting. I think that gives me clues as to the answers to the first two questions and a pretty direct clue to the answer to the third question. So I'm sorry, I do see hands raised, but if you don't mind, I would like to ask a follow-up question just because I'm curious and I like to ask questions, so forgive me. But how does this work then if, say, you're in a private apartment and the landlord has found someone, to move into a 2-bedroom because, someone is subletting and they're doing it through the landlord, so on and so forth. You're allergic to cats. This person has an ESA cat. How, what's the procedure there?
Usually you'd speak with that landlord to let them know that. If you have, especially if you're in a shared space, and you can request a reasonable accommodation that they're either not that cat be either limited in where it is in that apartment, or ask if you're in an apartment, you can maybe ask the landlord if there are other options for that placement, and you can also talk to the person who's potentially being placed in that space. I would be surprised if you're in a 2-bedroom and your landlord is foisting a roommate on you in a 2-bedroom without your consent. But I suppose that's possible. Usually you just kind of want to self-advocate a bit there and work with the landlord and the incoming tenant to see what works in your architecture, because the actual spaces vary so much that what is reasonable will vary based on your individual circumstance and space.
Have been there before with roommates forced upon me by a landlord, so that's interesting. Thank you very much. And I do see a hand raised, so I'm going to stop monopolizing.
All right. All right.
Rita, did you have?
Rita, go ahead.
Yeah, so I mean, maybe I'll be brief to wrap this up, but I guess so. Hypothetically, the person where Catalina is trying to move in, this section of the house where the only room available is, hypothetically, what if that were, a pet-free zone of the house or a pet-free hall or floor? Would it be unreasonable to shift people around to free up another room in a different place? I guess that my question is like, is a priority on keeping the current members comfortable and happy, perhaps at the expense of a potential membershipper, or is there an equal priority of membershippers? Does that make sense?
Yeah, actually, Liz, you want to take that one?
Well, I was going to say, first thing, it's not a pet, so the pet rule would not apply to a service animal. So even if there was a floor that is a no pet floor, if that member needed to go upstairs and have their service animal with them, they would need to be allowed on that floor. Like if that's the first floor for some reason, you have to go through it, they have to be able to take their service animal through that area. The same is not true of an emotional support animal. So then the reasonable accommodation can be that like that person needs to keep that animal in the room that is not in the no pet zone, if that is like a hallway or a room or a living room or whatever. So that's kind of, I think, one of those distinction moments between service animal and emotional support animal in that situation. Brel, do you have anything to add to that?
Not really a whole lot to add to that here. No.
Oh, I guess I will also say, if there is another room that is available, but the person picked the other room, that's another thing where you can't steer them to another room. If there's another member who's like saying they'll swap out and like take that room and like do that, you can't swap the rooms without consulting that person. If that's an accommodation that you want to offer and say you can offer up another room, but you can't steer them or like suggest that they would be happier in this room or something like that. That would be steering.
Yeah, you can definitely let them know that like there are options that might work out, but it's important to make sure that they're able to make an informed choice going into the space.
I think we had one more hand, but I think it was put down. Did somebody else have a question?
Yeah, hey, that was me. Can you hear me okay?
Yeah.
Okay. Yeah, so I think Frida kind of touched on some of my question here. Like the way these two questions are framed is it legal? And I guess I don't know anything about the legality apart from what you've shared today, but it really does seem unreasonable to risk Erin's health for someone, because I don't know. I just like there are many places to get housing, and Erin is already living there, so it does seem unfair in like a unique way to sort of put their health at jeopardy. And then it's just not so clear that it's a reasonable accommodation in this case because of that. But I don't know the legality at all. And I think to echo Frida's question, which wasn't quite answered, is like, what is the membership's responsibility to consider the needs and sort of comforts of people that are already living there versus new applicants to the house? But nice training, by the way. I really do appreciate you doing this.
Yeah. So yeah, tied to that, there isn't like a hard and fast, like the people who are there already have like some sort of fundamental priority with fair housing. Displacing someone, though, like displacing someone like it is something that you would, you don't want to do as the co-op. So that would be an action that is directly in opposition to your mission, and so you can definitely say like we can't displace people. That's like that's not an option for us. So it is reasonable to say that like this isn't something that we're going to do. We're not going to kick people out. We're not going to make the space unlivable for the current residents, because that would be a fundamental alteration to the operation of the co-op, right? We do need to that just letting a service dog in without making changes to how the house operates in a way that like allows for folks to be there would not be reasonable. What would be important for you to do would be then to try and maybe like look at some other sort of compromises or creative solutions that try to split the difference, where you're not risking someone's health to allow for an emotional a support animal or a service animal to be there. And I don't want to answer the question too hard here, but I see Liz raising her hand.
Oh yeah, I want to answer the question a lot. So I think the legal part is the part that you had a little bit of a question about. And I think the legal part is to not put the risk of your members at health, the health of your members at risk. So if you're risking people moving out because unlivable conditions, ongoing health problems, that is something that you can very legally say, no, we will not do this. It gets into more of a gray area if it's the comfort of your current members. If it is the comfort of your current members, that should not be the prioritized factor. So I think leaning into what are the needs here that need to be met, and what compromises based on the needs instead of the comfort. That's a really key part of like where the kind of legality lies in those priorities. I also, I want to open it up for more questions. I do want to note the time, but I'm loving the questions we're getting. Frida.
Yeah, I had a question about kind of the earlier stuff of basic broad discrimination on those categories, like federal categories, about applications. So language is not a, federal or local protected class, but it can be a proxy for national origin. So is there any kind of advice on applications? Should they be available in the most spoken languages in your area, for instance? Yeah, just broadly about that.
If that's possible for you, that lines up. So language can be a proxy. It is important to note that if you are if your co-op is completely incapable of communicating with an applicant, and you have no way of engaging with the app, because you're a co-op and because you have to actually do work with that member, that may be a barrier that you as the co-op might not be able to overcome unless you are able to find a translator or an interpreter to work with you. Maybe you can do that. Maybe that's an accommodation that you as a co-op can handle, and that would be well and good. And I would recommend trying really hard to do that. But if you're discriminating based on language, and that then creates a pattern or practice of discriminating against a specific class, then you're going to hit that that discrimination end. So if you are capable of posting flyers and outreach materials in multiple languages, and you have that support network within your co-op, I would say go for it. That can really help hit other marginalized groups. If you don't have that built into your co-op, if you're going to start reaching out to those groups, make sure that you do have the support the support network that's going to be built in, because you also don't want to just set people up to move in and then move right back out and not actually support people's housing security long term. And I see Noah with the hand.
Yeah. First, just how much time do you all have left for this? Because I have a few questions, but I won't ask all of them if you are running out of time.
I think we'll probably want to wrap up here maybe by 8:40, and then I see you and I see Andy on Stack, and you can definitely reach out. I'll just note that you can definitely reach out to us. You can reach out to the Wisconsin Fair Housing Council and the Tenant Resource Center for a lot of other questions too. A lot of like they've had a lot of, especially the Tenant Resource Center for folks in Madison. They've had a ton of questions from folks with that are in co-ops, and it's always good to kind of like poke them over there, because they're always a little weirder than the standard questions about fair housing and apartments and stuff.
Okay, yeah, I'll probably reach out to them for some of these then, but I think I'll just pick one. Regarding blocking membership, I know you said that we need to provide a reason for blocking. Would you also suggest having members provide a reason for voting in opposition? Because a lot of houses have in favor, opposed, or blocking. Would you also recommend having a reason listed for simply voting in opposition but not blocking?
I would, yeah, I would recommend that. Yeah.
And what our house currently does is we provide people with a list of acceptable reasons to block someone. Do you, I guess I'm just asking your advice here. Do you think that is a good practice, or should we have people explain their reasoning without having a list of options that they can kind of choose from?
If there is a list that can be helpful in framing, it might be good to say like these might be like these could include but aren't limited to like these reasons. You could limit it to those reasons if you want. Having a list makes it easier for people to really quickly understand, and that I think it like is a good practice to have like a list of reasons for blocking. I would be like, I don't know what your list actually says, so if your list is like really expansive, that might be really good, but I could definitely see there being like reasons why a person would want to block someone, and that might be justified in blocking them, that might not show up on that list. So I would just make sure that a list like that is clear enough to allow for folks to have kind of like a category under which they might block someone, instead of like a specific like thing that a person did that they get blocked for.
I also would uplift the like watching for patterns of behavior. If folks are saying kind of discriminatory things, but then picking something off the list at random after saying some things that are raising red flags, it might be worth like, having longer discussions and talking about what is a protected class and what are these things that we shouldn't be bringing into our decision-making processes. So having those things posted in the spaces that you're making these decisions are really helpful, or reading a fair housing statement before you start discussion can help people be thinking about the right things, are positive framing tools.
Yeah, that was the concern that I had, because that is something I feel I have observed. So that's why I wanted to ask. But that answers my question for the most part. I will pass.
Thanks so much. And then I'll let Andy ask our last question of the night.
Cool. So yeah, we have a policy that if someone blocks a membershipper, they need to give a reason that doesn't, very directly and explicitly violate fair housing. The reason that I've heard the most often is something along the lines of membershipper demonstrated or appeared to lack necessary conflict resolution skills for living in a 30-person co-op. Does that strike you as like an okay thing to be having to be the reason a lot?
If that's all that's there, I think that would be pretty likely to fall afoul of, or not like not likely to like be a discriminatory reason in and of itself, but likely to trip into the pattern or practice behavior, because it's really hard to verify that that's the case, right? And especially if you see like someone didn't appear to have the conflict resolution skills, what is that appearance? Like who doesn't have those skills? What skills specifically did that person need? Like conflict resolution skills could be anything. Instead, you want to say like, what did a person like do something specifically, or does this person not have a certain amount of experience? And it should be verifiable, as opposed to didn't seem like they did.
I think this is also where good record keeping can come into play. If that's the reason that folks aren't getting in, what was the example of that behavior in the interview? Were they short-tempered in the interview? Did they say things that were disrespectful? Could they not come up with an example of them resolving a conflict? I've been in interviews where the question is, come up with the time you've resolved conflict, and if someone can't answer that question sufficiently, that could be the flag that triggers that response. So recording like was unable to answer the question about conflict as the reason could be a really good way to track if that answer is being selected because of people not being aware of their conflict methods, or is it because you're basing it off of something discriminatory? So having a little bit more written down than just that I think would be useful to see if you're in a discriminatory pattern.
Oh, thank you. That's
all right. Well, thank you so much, everyone. We really appreciate all of your time and attention to this. Again, we'll share the recording of this out on NASCO's YouTube channel. We'll probably cut out the section where we're waiting in the beginning and stuff. Please do reach out to NASCO in the future too. If you are a group equity cooperative in the US or Canada, which all y'all are, or I guess a co-housing community in Milwaukee, you can reach out to NASCO for support. Also, this November 12th through the 14th, we have NASCO Institute coming up, where we'll have a whole bunch of educational sessions, as well as like a space to meet other co-opers from around the US and Canada. If your co-op is not a member of NASCO, we encourage you to reach out to us and join NASCO. It helps us support providing programming like this to groups like yourselves. Thank you so very, very much, and hope you all have a great evening.
Thanks, y'all. I dropped our emails in the chat if you want to get in touch with us.
Thank you, NASCO, for getting this put on. We really appreciate it.
Of course. Hopefully we'll be doing this stuff again.
Just feel free to send my email again with the recording. Thanks.
Great. And I note the request for a deletion from the YouTube version, and that will be deleted.